business to the next level. Just want to make sure we introduce our team. Bill, our amazing attorney.
Hi, everybody. Thank you.
Rachel and Rachel, but let's separate John and Steve. And then we also have Mary as well, our team. And we're working really hard to provide amazing customer service and just really elevate the experience for all the patient and outside agents as well. So I hope you guys enjoy the class. If you have any questions, we're here. And their cards are here. We can help you. All right?
Thank you, Sabrina, for the intro. Again, I'm William Anderson. I see some familiar faces here, some new faces, so welcome. You know, as Sabrina mentioned, I'm the attorney here with the closing team, our in-house title company. I concentrate my practice primarily in real estate, and I help realtors like you guys increase your business. Today, we're going to learn, is this the, oh, I changed that? Okay. Today, we're going to learn exit strategies in the Florida FAR bar residential as-is contract. Before we jump into that, though, I want to take a few minutes and ask you guys some questions. Specifically, what are the 3 qualities that a successful real estate agent possesses? So you guys take like a minute, write down 3 qualities that a successful real estate agent possesses. And then I have my list, and I'm going to compare, and we'll talk about that for a couple minutes. And if somebody could help me write down, I guess, the group's answers, that would be helpful. Fred, I don't see you writing anything down. Are you already done? Let's take a few more seconds. And whoever's done, if you want to raise your hand, or I'll select at random. Yes. Knowledge. Great. What was your name? Neela. Hi, Neela. Anybody else have a contribution? Fred? Okay, excellent. Tenacity. Okay, it's good quality. Perseverance. Integrity. I haven't heard. Negotiating skills. Those are all good. Anybody else? Sharon? Patience. That's a great quality to have. So I've heard a lot. My 3 are knowledgeable, communicative and available, and likable, friendly. You know, I think, you know, and I think these 3 qualities are important whatever sales job you have, whether it's selling real estate or selling legal services or, you know, or selling widgets. You know, personally, I like, you know, I like somebody that's, you know, dealing with somebody that's knowledgeable, and I prefer dealing with somebody that's likable too. I mean, you know, I didn't really hear that, but you know, those are just my 3, not that they're the 3 end all be all of the answers. So without further ado, let's start into our presentation here. Exit strategies. Anyone know, we can take a stab at what an exit strategy with this contract is? Does anybody know an exit strategy? Inspection clause, very good. Anything else? What's that? Appraisal could be one too. Mortgage, financing. Excellent. You've touched on a couple of the major ones that we're gonna, oh, this is not working. How do I press the middle button or the side buttons? I was pressing the side buttons there. Use this. How do I? There you go. Okay, yeah, I just put this little graphic here just as a your get out of jail, your exit strategy. All right, wait, where are we? Technical issues. Okay, well, I have three. I can't switch over. If somebody could switch over to the, yeah. Technical difficulties. Excellent. All right. Somebody mentioned inspection period. How long is the typical inspection period? 15? So if you don't do anything on the contract, it's going to default to 15 days. Now, that might be enough time. It should be enough time. I mean, if you use a pretty good home inspector, you should be all right. Contingencies, you have obviously, you know, your inspection is considered one. Financing is a big one. You know, if you have to sell your current home, that's another contingency. You know, I've seen a bunch of different ones. And then if, you know, the last one that I have, well, I think there might be even one down here too. Condo purchase sale, if it's a condo, this one I actually learned a lot about. Not only do you have to be approved by, you know, the association, but you have to get all the documents. And all the documents under the Florida statute, you guys would be surprised at what you need to provide. You really would be. I don't know if you even know what you need to provide, but it's a lot of stuff. And number 4, the last strategy is pretty much just, you know, if you don't have any other of these available strategies to back out, negotiate your earnest money deposit. That's really your last one. So we'll go into more of these. Here we go. Okay. So you guys are also aware that, you know, we primarily use the as-is contract. There's the standard FAR contract, which the inspection period is a little different in the sense that there's a repair obligation for the seller. The seller has to make repairs up to a certain amount that's provided and, you know, that they agreed upon. But we're not going to really discuss the standard. We're going to discuss the as-is. The great thing about the inspection period is the buyer has, in their sole discretion, without having to provide any reason whatsoever, within the first 15 days, if it's 15 days is selected in the contract, they can back out for whatever reason, as long as they make the deposits and, you know, have a, you know, and they don't even need to have technically an official inspector inspect the home. You really, in the as-is contract, the buyer really has 15 days to, you know, take it or leave it. And, you know, if you guys don't know that, you really should. The seller really has no, you know, their input in the transaction at all during the 15 days has really no bearing whatsoever. So if the buyer says on the 14th day, hey, I'm done with this contract, they're done. So that's the inspection period. Absolutely.
Let's say you go to 2 to 3 days, 5 days. Pre-inspection period, deposit is due in 3 days. Do they really have to take that deposit?
Yes. Okay, so the question for the folks online, can everybody see me online and hear me? Somebody chime in. Yes, okay. The question is, does the buyer still need to make the deposit? So you're saying in the contract, the inspection period is limited to 3 days? Okay. And at the end of the 3 days, the deposit's due? So technically, no, they don't have to make the, I guess it would be the initial deposit unless there's the deposit that was made with the contract. That's, those issues are very common. And, a lot of realtors and buyers and sellers kind of like to intertwine all those issues when, they are considered separate obligations though. So in a 15-day inspection period, the deposits are due, one with the contract and one after 5 days, which is kind of the typical scenario. Yeah, obviously those deposits have to be made. If during the 4th day, for example, the buyer says, no, I'm going to cancel the contract. No, they don't have to put on the 5th day, they don't have to put the second deposit down. And again, in my practice, I've seen these situations, and I'll provide some other situations from my practice that you guys will find relevant. But yeah, I know what you're saying there, Joe, and in that situation, no, you don't have to make a deposit, but be careful with the timelines. As you guys know, the timelines are very important. So let's skip over to the next one now. Okay. Everybody knows the financing contingency. Okay. The buyer's purchase is contingent on the buyer obtaining a loan. In my practice, I've seen buyers drag their feet and not apply for the loan until it's too late. So the buyer definitely has to make a good faith effort into applying for a loan. The financing contingency provides a certain time period for which the buyer can obtain, the loan approval or the loan denial. What I see a lot with you folks is, the buyer has applied and now the lender is kind of dragging its feet, or it's end of the month and they're busy, and then now we need to get an extension. So what the typical extension that I see is, okay, we're going to extend the contract for 5 days to closing, but it doesn't extend the financing contingency. So be mindful if your buyer is in a situation where it's kind of in flux or in doubt as to what their ability to still get the loan is, extend the financing contingency also. That's you can most definitely do that with with your addendums. The kickout clause, the second one, sale of the current home, that's a big contingency also. I know some of you guys even had those deals just recently. That's a big one. The buyer has to, in order to buy, the buyer needs the funds from the sale of their home. And an appraisal contingency, back when I started 20 years ago, the appraisal contingency was kind of wrapped up into the financing contingency, but they're really separate issues. And a lot of the contracts that I've seen deal with having an appraisal, the home appraising at at a certain amount. If it doesn't, then they can renegotiate, or at that point, call the contract terminated. But the appraisal contingency is more of kind of like, if it doesn't appraise, it's kind of like a renegotiating time period for that. Any questions about, yeah, go ahead. Yep.
I've asked this before, it's kind of gray area. The appraisal contingency, if let's say it appraises below, okay, but the buyer has $1 million in the bank.
Mhm.
The bank will come along and they'll say, we'll still be below the money. Even though the property is appraised, it's still be below. Does the buyer still have an out? Because the bank is saying we'll still be below, based on their finances versus appraisal.
Okay. So for the people online, the question was, is if there is an appraisal contingency and the buyer has sufficient funds available through a loan, is that the question? Or so we have a financing contingency too? Okay. Okay.
If even appraisal is less than the value of the bank,
Okay, so the financing contingency, you guys, if you look closely, has parameters for loan terms and loan amounts. And your contract, obviously on the first page, on the right-hand side, you have financing amounts and all that. So the question is, well, if the property doesn't appraise, how does that now affect the financing contingency if the bank is still willing to lend the money? And in that scenario, the bank is still willing to lend the money, although the loan amount is going to be increased, or the cash to close amount is going to be increased. So they're essentially changing the terms of the financing the terms of the contract. So, you know, the argument can be made that because the terms are being changed, the financing contingency, you know, is still in flux, and the buyer through the lender can obtain some sort of denial letter based on the original terms of the contract. That's what I was saying, is that, yeah, even the bank, first of all, the bank won't waive the financing contingency. If, let's say, for example, the house, you know, appraises $10,000 less than what the original loan amount was. So either the lender has to come up with another 10,000, or the buyer has to come up with 10,000, or the parties can readjust the purchase price. Again, at that stage, that's a renegotiating position for the realtors. Can the buyer back out? If they haven't received a loan approval letter, and you know, it's possible that they could receive a loan denial letter based on the original terms of the contract. So that's a tricky one to negotiate, Joe, because, yeah, I mean, I see what you're saying, in the sense that if I was representing, you know, the buyer, and, you know, if they were cash strapped, then, you know, would they be willing to increase their loan amount? They might, you know, they very well might. But, you know, there's also a situation where they might not, you know, they might not be able to afford 10,000, you know. And again, if the lender reran the numbers and went through underwriting, and now you're at right before closing, the lender's like, you know what, you know, now we ran the numbers again, and, you know, based on the new loan amount, he's not going to be approved. So the underwriting situation that's completely foreign to me, and I'm sure to a lot of you as well. So we won't really get into that. But yeah, just be mindful how, I guess, again, the interaction of the appraisal contingency and the financing contingency. And if, you know, if you have the trifecta in that same contract, well, you know, You have a lot of praying to do. Yes, Karen. Yes. Okay. Thank you. Mm-hmm. Yeah. 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 Okay, so the question in the room is, we have a kickout clause where the buyer is selling their home. Closing is set for the 30th. The sale of the home is set to close on the 20th. And then you have a financing deadline for the loan approval, loan denial on the 13th. That's a great question. Okay, so the closing date on the 20th, as we all know, may or may not happen. I think and you can't control that. I think what you can control, you have more control over, over the loan. And I think, what you would need to do is, still proceed forward with the loan, get the loan denial. I mean, but if, again, the other question is, will they be approved if they don't sell the home? So on the 13th, if they haven't sold the home yet, the loan could still be contingent, according to their conditions or whatever for the lender. It would probably be contingent on that sale. Yeah. 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 Then, so yeah, you may want to. I think the loan approval and denial is definitely premature on the 13th, because you have to wait until the 20th to see if they're going to sell their home or not. So you may want to extend the loan approval denial period until at least the 20th, or make it run alongside, when they're going to close. So whether, 20th or whenever their home is going to sell. It doesn't have to be on the 20th. Fred.
The inspection was done. They sent the 4-point inspection, windstorm, part of the inspection. Everything was fine. 5 weeks later, they sent a 4-point inspection, and it came up that it had aluminum wiring, so they couldn't get insurance. Luckily, the buyer and seller agreed to split the cost. What was my ramification? Go after the inspection company?
No, you have two. The question is, there was a home inspection period has lapsed. Okay, there was a home inspector that went out to the home, provided a report. Okay. 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 So those are two different issues. Okay, you have your home inspection issue, which is the inspection period for which the home inspector goes out, checks the home, and then provides a report. During that time period, the buyer can review that and then make a determination. And then you're saying that for insurance purposes, the buyer had the home inspected for a 4-point and for the wind mitigation. That is for the insurance purposes for the buyer, different than no. The inspector, there's an insurance inspector that would provide that 4-point wind mitigation. That's for the borrower's homeowner's insurance and wind coverage and all that. That's not for the initial 15-day inspection where the buyer, looks at the house, say, okay, well, they're, based on my interpretation and based on the home inspector's report, this home is suitable for me and I'm going to move forward. The 4-point and that's for insurance purposes. Those are separate. You may pay the same inspector to do both. Yeah, but typically those are considered two different scenarios.
Let's say they didn't work it out. I'm not going to spend $1 million wiring. This is a buyer close. Insurance, the property related condition will be another out for the buyer. They weren't able to do insurance.
No, because the question is, so after the 15-day inspection period, through no fault of the buyer and the seller, the inspector provides another inspection for insurance purposes. It's determined that there's faulty wiring or something to that effect. No, at that point, the buyer has waived the 15-day inspection period and is deemed to accept the property as is. Yeah, and which they very well might. They very well might if they get their hands on that. Yeah. True. Yep. Yep. Yeah, they have to have insurance, and in Fred's situation, I'm not sure if they were going to have yeah, but they might not have been able to get either. Were they able to get insurance at all, or was it just going to be more expensive? Oh, okay. Okay. Excellent. Yeah. So, yeah. Wait. Okay, I got it. Okay, so I think what you're asking, so the question is, does property-related conditions in the contract, if the conditions are substantially different than what the initial. Sure. No, that doesn't. Yeah. I think the property related, I'll be 1 second, Sharon. I think the property related conditions, and without having the contract in front of me, I think what that's getting at is, is the property in the same condition as it was when you went through your initial walkthrough, less wear and tear. If that's the case, which I've seen also, you go through your walkthrough and then you go to closing and the AC doesn't work now, or there's they stripped out the washer and dryer or something that it was supposed to be in there, which I've seen all that. So yeah, those are, I think that's the same portion of the contract that you're referring to, Joe. Sharon, yes.
Before I send out the appraiser, we need to get the electrical stuff taken care of. If the appraiser goes out and says this isn't going to pass,
Yep.
then I understand this is a delay.
Yeah.
So that's another issue. I think with some nonsense or
yeah.
Stuff with the communication point that needs to pay attention, even though the inspection period is well over. We need to do that.
Yeah, the comment on the floor was, there was another contract that had electrical issues that arose during the inspection. Yeah. Yeah. So this is so the folks online, this is a finance transaction. Electrical issues came up during the inspection period. We're past the inspection period now, and now the lender has said, you guys better take care of this and resolve this electrical issue, because the appraiser is not going to properly appraise the home, and then you're going to get a loan denial. So you guys can see how, you know, these issues that arise during the inspection period can spill over and then cause an issue with the financing contingency. So yeah. You know what? I think you probably should, as a good practice. Probably the best practice is, if there are issues during the inspection period, you know, and you'll have a feel from, you know, the other side and from the seller, like, well, if they're going to be, you know, if the seller's going to be difficult about, you know, working with me, then, you know, I can already sense that I'm going to cancel the contract now. But if they're going to work with you and resolve these issues, and, you know, again, I see this all the time. If you have two parties that are going to work with you to resolve these issues, yeah, have an extension. But if not, you know, and you can, again, go on your gut instinct and yeah, absolutely. Absolutely. If it's a finance contingency, I don't think you need to do an appraisal addendum. You know, I think the appraisal contingency is, you know, and again, but if it's not finance, how many people do appraisals? So, you know, the question is, do we need to do an appraisal addendum, whether or not you have a financing contingency? I mean, again, like, would I, if I was the realtor, do an appraisal contingency? Probably not, but it depends on the situation with the particular home, because if you have one of those unique homes and, you know, you know, and the purchase price is way high, you may want to do an appraisal, you know, contingency, because you know, you guys know a lot of your sellers, their, you know, image of their own home is, you know, is like a castle, and they overinflate the value and everything. So, you know, you may want to do that to bring everybody back down, you know, to reality. But again, that's, you know, and I see this all the time too. You start getting to the point where your contracts get more and more complicated, and then layers with contingencies and all that. But, you know, again, you know, you're, as the realtor, you know, your goal is obviously to sell the home, but, you know, selling the wrong home to somebody is worse than not selling, you know, a home. And where you can do your clients the best, you know, the best business practice is, I think, you know, cautioning them properly and having exit strategies and all that. Yes, Joe.
You know, the market's starting to go down, so appraisals are not going to come in. So if you're concerned, you've got the buyer, and concerned that the appraisals are not going to be, you've got a wealthy buyer that's getting cash with financing. You might want to protect the buyer, because your appraisal probably not appraised, and the buyer might still lose loan because they are satisfied with the buyer's connection.
Yeah.
And so in that situation, the market kind of gives you that more appraisal that start happening. Wealthy buyers with cash.
Yeah. Yeah, no, the comment on the floor is, you know, there are wealthy buyers that could pay cash and also could decide to go through financing, and then it might be a good practice to have the appraisal contingency in order to force the hand of the seller and get a, you know, strike a better deal. So we're going to move on to the next slide. Yes, question. Yes. Question. Oh, thank you. Let's scroll. Wait, I don't know how to control. No. I'm going to go with Terry. Terry Malone. Hi. So if you make a specific date that is later than the 15 days is the calendar date, the opt-out date. So later than I think the question is 15 days on the, if you make the 15-day inspection period as a calendar date. Yeah, I mean, you go by calendar dates, not business days. I think that's the answer, but Terry, you can follow up if that's not the correct answer. Terry has another question. The 4.8 going to come back and not the, does this qualify as a, if it does, if it's during the financing contingency, yes, the buyer can receive a loan denial letter. It might be better ordered with the initial inspection. And I think that last one is a comment from Terry, and I think that's a good comment. It might be better to order the wind mitigation and 4-point with the initial inspection. Fred, on your transaction, was the inspection ordered, the home inspection and the 4-point wind, were they all ordered at the same time? Same day. Yep. So, yeah. 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 Sure. Yeah. 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 And the problem, what Fred's saying, Terry, I think this is relevant to what your questions were, is, yeah, even in light of the fact that you're ordering the home inspection, the 4-point, the wind, all at the same time. In Fred's situation, he received, one of the inspections a few days before closing that disclosed an issue. In that point, where's your recourse? To go after the inspector? By law, just so you guys are all aware, the home inspector's liability is limited to the amount that you pay them for the inspection. So, because otherwise they would be exposed to liability for all these issues and all that. So, just so you guys are aware, a little nugget for you. If you're in a condo situation, this is a exit strategy that I was familiar with, but not to the extent that that some of these condo docs issues present. You guys know that the seller must provide the condo documents, and then and then the buyer has 3 days, a 3 days review period, cooling off period, and as soon as the buyer receives all those documents, you start the 3-day clock ticking. But this is the big one. So this is the Florida statute here. The seller has to provide the declaration of condo, the articles of incorporation, the bylaws and rules, the financial information, and then also a document entitled Frequently Asked Questions and Answers. Okay. So, and then on or after January 1st, 2009, the prospective purchaser shall also be entitled to receive from the seller a copy of a governance form. So there's another form, and I guess this is, I don't know if I can scroll. Oh, I can go that way. There's another form also. So this is the big one for you guys to understand, because if the seller doesn't provide all these documents, the clock never starts on the 3 days. Never starts. So, and it expires at closing. I'm going to, yep. Exactly. Yep. And or the condo association will provide, like maybe a balance sheet and not, some of the other financial information. So what I said before is that by law, Florida statute says that if the seller provides all of these documents, everything that's included here, that the buyer then has 3 days in which to review. And if the buyer has a pickup truck and the condo doesn't allow pickup trucks, buyer can back out. If the The buyer has a trampoline set and the condo doesn't allow that, the buyer can back out. But the important point for you guys to understand is if the seller doesn't provide all of these documents, the clock for the 3 days never starts. And the clock only ends at closing. So the buyer can walk into the closing room and say, I've never received all the documents, back out of the contract at any time. Yep. Yep. That's a statutory, this is a Florida statutory provision. Yeah. Question? Aha. That's how the seller can surpass this issue. If the buyer then checks off that they've received everything, the clock starts ticking. And then 3 days, boom. So the question, oh, I'm sorry for the people online. So if the buyer selects that they've received all of the condo documents, that starts the clock ticking. And then the buyer has their 3 days. And then after the 3 days, they've waived their right to cancel and they have to go to closing. Question, Fred? Yep. Yep. Yes, sure. Yep. The clock doesn't. So the question is, some of the condos that are self-governed, operate between 12 and 2 o'clock on every other Thursday. How does the seller obtain all the documents necessary in order to start the clock ticking? Well, if the seller can't and the condo doesn't have the documents or makes it difficult to provide them, your buyer's clock never starts. It's a Florida statutory law that be aware, be advised if you guys are representing buyers and they're getting cold feet and they haven't received all these documents, you can rely on, Florida statute 718.503. Yeah. Yeah, that was actually a learning experience for me because one of our closings, somebody didn't have a frequently asked questions. And the buyer had an attorney and the buyer was, well, we didn't receive the frequently asked questions. Like, really? I got to research that because I wasn't aware. Did you remember that? Oh, okay. Yeah. Yeah, they just exit. Well, they asked, yeah, there's questions required like, where do I, get my mail, or, where does the condo have storage, or, questions that, that the condo would typically provide. But the condo, a well-run condo would know what these statutory frequently asked questions are, and and if they're properly managed and or they have a management company, they know what these documents are, and those all have to be sent over. Yes, Joe. Yep. Yep. So the question, so the question online, folks, is if the buyer selects that they've received all the documents, but yet they have not received all the documents, the buyer is out of luck. They've waived their right to cancel. They've deemed to have been in receipt of all of the condo docs. So there's no turning back after that for that. Yes, question.
Re-sign the condo thing after she gives them all to you. It's all there in email.
So the question is, I have a question. So did the buyer check off that they've received everything?
Yes, they were one of those things out of all the things. And an email was sent to her requesting one thing, one facet.
Yeah, see, the presumption is if they check that off, they've received it. So, but, can you rebut that presumption by your other, email from an agent? So the question is, if a buyer has checked off the provision that they've received all the condo docs, but yet there was an email from an agent of the seller saying, no, we haven't provided you with everything. Yeah, though that's a kind of a fact and, a specific situation that, that's ripe for attorneys to have to argue over. Um, you know. Yeah, exactly. I mean, those are the questions. Like, why would they check the box if they didn't receive everything?
So, and you can't like go for all that stuff and give it to an email,
So,
and then you're signing it and you receive it, but you're.
gotcha. So the comment is, sometimes the buyers are presented with a contract and they're just signing their life away, like they sometimes, so they can get the docs, but yet something's left out. Practice. I mean, this is a very important point for you guys to, hammer home is, don't say that the buyer has received all the documents that they haven't. I mean, if they're getting like a stack of, 4 inches thick of a book, I guess you kind of have to make the assumption that everything's going to be in there without flipping through everything. So I see what you're saying. But yeah, it's always best to hold off and checking that, because again, you just don't know what's in that packet, and the seller's not going to know. Seller's not going to be, know about this, what they should provide. They're just going to hand over what they were handed over. Yes. I think your duty, at this point, your duty is not to necessarily check to make sure that, yes, I think your obligation as a good realtor, a knowledgeable realtor, is to say, buyer, don't check this off until we've examined everything, and and tell them why. Yeah, just hold off. That's, if I can impart anything today, don't check the box as the buyer has received all the condo documents if they're buying a condo. Okay. Let's go to the next one. What's the next one? Okay, that's got cut off. So you've gone through the contract, the period, the financing contingency is now waived, the buyer can get financing, the buyer's inspection period is over, and now the buyer is like, either I can't afford, I really can't afford this, or I don't want this particular property, and they're having buyer's remorse. What do you do now?
The worst scenario is they can lose their escrow.
Correct. That's the worst scenario. Yes. So the comment on the floor is the worst scenario when the buyer has it's either a cash transaction and there's no contingencies further, or it's a finance transaction and the buyer has the loan, and now the buyer gets the closing, or before closing is like, listen, my aunt just died, I can't afford this place, or whatever. The recourse for the worst case scenario for the buyer is they lose their earnest money deposit. In my practice, does that happen? Yeah, it happens some of the time, but most of the time, that's again a negotiation situation. The buyer can agree, hey, listen, seller, I know, you're out monies for, your mortgage and blah, 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 blah. Let's split the deposit. What it becomes more interesting when the earnest money deposit is like 20, 25% of the purchase price. And we're talking real money, not $1,000, but 50, 60, 100,000. I mean, I had an escrow deposit dispute. It was $120,000. and it was a condo, and it ended up after probably a year and a half settling at mediation. But yeah, so the buyer, the buyer and the seller in my particular situation each had legitimate points, and if it went to trial, who knows? Roll the dice, and the buyer could have won, the seller could have won. So they split it. They split it down the middle. Yeah. Yes. See, okay. So the worst case scenario for the seller, and the question on the floor is, what if the seller changes their mind? What's the recourse for the buyer? Now, the recourse per the contract is that the buyer has to file a lawsuit. It's called a specific performance complaint, and what that is a complaint saying I have a valid contract. I've done everything that I was supposed to do with respect to my rights and obligations with the contract. Now, judge, sign off on an order saying that this seller has to sell the property to me according to the contract price. Practice, in real practice, does that happen? I've seen it probably 2 times where the buyer has been that hot and heavy over a contract and has gone to the point where we filed suit and negotiated the sale of the property. Most of the time, it's one of those situations where unfortunately it's mostly cost prohibitive for the buyer. The buyer has already put down a deposit of whatever amount it is, typically 20%. And, and they've paid for the inspections, they paid for their appraisal, they paid for financing, they're already in the hole, it could be 20 grand. Now, are they going to want to pay, an attorney another 5 grand for, an indeterminable amount of time where a judge is going to, eventually rule? So, in practice, I don't see it a lot where, where if a seller defaults, what the buyer's, recourse is the specific performance lawsuit.
Plus the additional profit that maybe the seller sells for profit.
Yep.
More.
Possibility, yeah. So the comment on the floor is that if the seller then breaches the contract and the buyer's recourse is specific performance, and then the seller goes ahead and sells the property, they had somebody else on the back burner that wanted to pay more. So the damages now for the buyer are, specific performance plus whatever the lost profit is on, on that house. Yes, that's.
Let's say you find out the seller sold the property a year later for $100,000 more.
There's a statute of limitations. So the question is there a statute of limitations on that? I think I'd have to research the statute of limitations. I would think it's 2 years, but I would have to check on that one, Joe. So let's go to, I don't know if I'm running out of time. I might be. So what do you do? God, this thing is cut. For the buyers, if you represent the buyer, this is what you guys need to do. Okay. I always tell people that when they represent a buyer, put as small as earnest money deposit down as possible. $1,000, is sufficient. Sellers always want more. Number 2, use the as-is contract, select 15 days. Have a good qualified home inspector to get the inspection done as soon as possible. If there's any issues, that 15-day period is the easiest way to get out of the contract. Number 3, in a finance transactions, obviously paying close attention to the effective date, and the timing of the loan approval, loan denial time periods. You guys have to know the effective date of your contract and how the effective date of the contract interplays with the loan approval and loan denial letter. You know, and if, again, if you're, as I mentioned before, if your buyer requires extra time, an addendum to close, get the extension without waiving the financing contingency. Have the financing contingency as part of the addendum. So if you're extending it for, you know, 5 days, extend the, you know, the financing contingency for as long as you can. And again, as we just discussed with the condo purchase, obviously make sure the buyer receives all of the, you know, the condo rules, and do not have the buyer check off the box that they've received everything. Once the buyer receives all those documents, you know, they have the 3-day period. During that 3-day period, they can cancel the contract, just like they can cancel the contract during the inspection period. But be advised that it's only for a condo purchase. And then, you know, if all else fails with that and you don't have any of these situations, obviously call an attorney that practices in real estate, and be prepared to negotiate the, you know, the deposit. If you represent the seller, you know, you definitely want to make sure that your seller is receiving the buyer is putting forth the largest earnest money deposit. You know, continuing on that, for a seller, if you have a large deposit, whether it's, you know, and I consider a large deposit $5,000 and on up, you know, that for a seller is, you know, honestly, if a buyer defaults, the seller just sits back and makes a claim for the deposit and just waits. You know, they can either, you know, the buyer has to chase their money. The buyer has to go through the title company and say, hey, listen, I want to make a claim too. The title company at that point says, okay, we're not going to release the money until we either have a court say we can release the money, or the parties, both parties agree on whatever the amount of the settlement is. The seller doesn't have to do anything. The buyer, if the buyer wants the deposit at that point, they have to follow the terms of the contract. They'll have to go to, I think it's mediation first, within the first 10 days. Most people don't do that. And then, you know, after that, you have to start a lawsuit. The buyer has to start a lawsuit. So for the seller, you know, you want your clients, you know, if you're representing sellers and listings, you know, you want to have the largest earnest money deposit possible. If the seller is selling a property that's in really good condition, you know, use the standard contract instead of the as is, because the standard contract, you know, the buyer has the inspection period, and then whatever is disclosed that the seller needs to repair, there's a repair allowance. Let's say, you know, it could be $1,000, $2,000, and the seller has to repair that, and then they go to closing. If it's a property that's in really good condition, you know, the standard contract is where you want to be if you have a seller with property in good condition. And then, you know, if it's a condo sale, just make sure that you have, you know, your seller has all the condo docs, and your condo has all those documents available, because, and then, you know, make sure that the buyer doesn't check off or checks off the condo addendum that they've received all the documents, because that way, you know, that 3-day clock, you know, runs, and the buyer can't back out. Let me see if there's any questions online. Do we have any questions here, Fred?
Money down the escrow deposit. It was a forced sale by owner seller. During the inspection period, they found out that the roof had problems. Found out that all so the buyer was backing out.
Mm-hmm.
The seller wouldn't release the funds, but because we had it, we took care of it. What would the process be if it wasn't the escrow money was at another program?
No, well, You know, if it was in a real estate brokerage, that would become a FREC issue. I have dealt with that. In my experience, I haven't dealt with it in a long time, but I've been told that the process is a lot faster now in terms of FREC deciding on escrow deposit disputes. I've been told that. It's definitely not my experience with FREC. But in those situations, yeah, I mean, the parties would have to lawyer up and, you know, and then duke it out, because now you have a buyer and a seller that have an escrow deposit dispute, but then you also have potential escrow agent that's not dispersing the money properly. So yeah, I mean, you'd have to have, yeah, in that situation, if it's clear, if I was the escrow agent, I would have the ability to use my judgment and discretion in that scenario where I can see, oh, well, the buyer clearly is within their inspection period, they get their money back. You know, a lot of title companies don't want to even take that, you know, position. They're very skittish about, you know, gross negligence and dispersing to the wrong party. So, you know, in that instance, yeah, you'd have to unfortunately have legal, yeah, you'd have to have legal help. Yeah. If it's during the inspection period, you can. Best practice is to have that signed. Yeah, have that signed.
Do they apply in the non-conflict transaction, say REO, or probably about an auction? Does the bank or the party selling the auction have to provide the contract?
That's a great question. This is the condo document statute. It's by Florida statute, so it can't be waived by any signing, or the fact that the seller is a trust in, you know, in Minnesota that has a portfolio of properties, and that might not have it. They have to comply with the Florida statutes. Yeah. So the question on the floor is that if it's an REO sale with a bank that has assets and, you know, and portfolios all over the country, and do they still have to comply? Absolutely, with the statute for the Florida condo statute, they have to comply with that. If it's a condo, yeah, there's no contract at that point. Yeah, there's no, yeah, you're buying it at the, you're buying it at the steps. So the question was, what happens if you're buying a property at the steps of the courthouse during a foreclosure sale? Yeah, since there's no contract with respect to that in the traditional sense. Is there any other questions? You need me, G? All right, Joe.
If an investor is a special warranty deed, let's say they own the property for a year or two, is it advisable to special warranty on that?
Yes. So the question is, if it's an investor seller, can they insist on a special warranty deed in the contract? And the answer to that is absolutely yes. I see this all the time. You know, the special warranty deed kind of, it's like if you're looking at a hierarchy of the deeds, quitclaim deed, special warranty deed, statutory deed. So it doesn't have the same assurances that and promises of clear title that a statutory warranty deed does. So that's why the investors use the special warranty deed. So absolutely.
If it's not, you know, in the contract, it's not spelled out in the contract, and the buyer seller is agreeing with that warranty deed.
So the question is, so you have a seller now that's requesting a special warranty deed, and you have a buyer that is that wants a statutory warranty deed, and they're butting heads. The contract, the FAR contract, doesn't make mention of what type of deed, but let's say it doesn't. So if in the absence of any wording with respect to what deed is, it's something that you would have to negotiate, because that could kill the deal. It could easily kill the deal, and I've killed deals on that, you know, where I was representing the buyer. Yep.
So there's nothing in the contract that spells out the buyer still has to.
Yeah, there. In that instance, you know, you both parties have signed the contract, and it appears that you don't have a meeting of the minds as to what type of deed to be used. So in that case, yeah, I mean, I don't think there are any issues. In a perfect world, there wouldn't be any issues in canceling that contract. Those are the facts that, you know, I'm making for purposes of this argument. But the contract does provide, the FAR contract does provide specific language as to, you know, what deed, and without me looking at it, I don't really remember what it is. But I don't know if it's you have to have at least a special warranty deed or a statutory. I'd have to check the contract, but yeah, the investors typically are, you know, wanting a special warranty deed. Yes. Quick claim, a special warranty deed, and then the statutory warranty deed. Yeah. Yeah, and if I was gonna stack them in like a hierarchy of, you know, worst to best. Quick claim deed is, you know, essentially you're getting whatever title the person that's giving you the title is. So if they have 3 mortgages and, you know, and 4 liens, you're inheriting that. Okay. If it's a warranty deed, you know, and without getting too technical, special warranty deed is providing warranties as to, I think, as to title ownership, but it's not guaranteeing that, you know, that they're providing other warranties, such as, you know, and I have to check the statutes on that, but they're just saying that they have title and that they're passing title over to you. Statutory is, you know, they're claiming that they have clean title, and then they're passing clean title over to you, and they'll defend, you know, any outside parties that are claiming title, and then there's a few other warranties also that come with the statutory warranty deed. That I'm not entirely comfortable with the client receiving, you know, the special warranty deed. If that is the case, you know, obviously you want to run, you know, all your title searches, lien searches, and, you know, and have title insurance and all that. But yeah, your seller in those cases is basically saying, you know, I own this property as is. I don't know anything about this property. This is what you're getting. This is what I have. Don't look at me for any issues in the, you know, in the future. That's really what, you know, what it is. Yes. 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 So the question, the comment is, would title insurance protect somebody that purchases with a special warranty deed? And yes, it does. The special warranty deed really kind of absolves the seller of any issues with title or ownership and such. Yep. Yep. If I'm representing the investor, yeah, yes. So the question is, so if I'm handling a closing and I'm representing an investor, to best protect my client, which would be the investor, yes, I would recommend having a special warranty deed. especially if they don't know anything about the property. And those REO situations, like you mentioned, Joe, is where you see this 100% of the time. The REO company buys, could buy 100 properties in one and have in one portfolio. They've never stepped foot in the property. They don't know anything about it. They're not going to warranty a water heater or anything with respect to that property, even the ownership of the property. They've got to, they receive title through a foreclosure sale. So most of the times. Yeah, the title insurance would cover that. Anybody else? Probate? We'll do a probate seminar. Yeah, we're going to do a probate. No, well, you can ask me that after, though. But guys, thank you for your time. It was a pleasure being here. And make sure you use the closing team in all your future closings.